All right, good afternoon, everybody. Welcome to our final webinar for the 2019 Con-Massey-Carey MSHA webinar series, and thanks for joining. So welcome. Today's webinar is Requirements and Limitations of MSHA Citations and Orders. So the thought behind this is to discuss not only those citations and orders that we're all aware of, the 104As, but also the other alphabet soup, as some people have called it, of MSHA issuances that we could face. We'll also be looking at a couple areas of how strategy might be able to help us figure out how to best handle those. As in the previous webinars, I'm your host today, Nick Scala. I am the chair of the National MSHA Practice Group here at Con-Massey-Carey, where we assist companies in essentially all aspects of dealing with the agency, whether prior to citations being issued or afterwards for contest, or reviewing agent of management or discrimination interference claims and defending companies in that regard. So, you know, we have the ability to work with companies around the country, and we take a lot of pride in helping them navigate their MSHA or other types of workplace safety issues. As I said, we're going to do an overview of the citations today and then talk about some strategies on avoidance, and that will probably be piecemeal with each time we're going through a different type of issuance. Another part of it will be managing abatement of the citations and orders, because especially when we're talking about 104B orders, which are failure to abate, that is obviously a key element of avoiding the citation. Lastly, throughout the day, we'll touch on different time periods and different deadlines for contesting the citations, because while every citation can be contested, the times that you must file that contest are different, especially when we're looking at a few of the withdrawal orders that may not carry penalties with them, or do not. So, with that, look forward to a good discussion today on the topics, and we'll go ahead and get started with this type of citation that you all know already, or at least I hope you do. So, MSHA's primary enforcement mechanism, it is the 104A citation. We should be familiar with these. These are what are most commonly issued by the agency. They can carry a penalty of anywhere from $130 up to $72,000, or even higher if we're getting into flagrant issues, which we'll talk about later. But this is where we begin, and this is where we have to look at understanding how citations are issued and how negligence is assigned and how the gravity is assigned, because these affect what or how we get to the following classifications, whether it's 104B orders for not abating or 104D orders for an unwarrantable failure. So the 104As are a bit of that basic element. They'll list the standard that is being allegedly violated. They will make a determination on the gravity and severity, which will be the likelihood of the injury occurring. That is that gravity is that unlikely, reasonably likely, highly likely classification. Severity is what we're talking about, their estimation of what the injury could result in. So lost work days, permanently disabling, a fatal injury. Those two classifications are important in determining whether or not a citation is significant and substantial. Now there is a test that we'll review here in a slide or two, but S&S we obviously know is a bit more of an elevated citation. It has a potential for causing higher penalties depending on the other issuances. It is a bit more of a red flag if we are a contractor on our record. We want to make sure we try and get as many of those removed as possible for the processes of pre-qualification on contracts. Also, if we're an operator, an S&S citation is a bit of a red flag to an inspector when they come back out. In addition to that, we'll have a talk about the negligence, because that is another important element when we're talking about the different citations and orders that can be issued. It's important when we're talking about negligence to remember that the Mine Act is a strict liability statute. So what does that mean? That means that you can be found at fault without any negligence being present. Oops, I apologize about that. And that is why the definitions of negligence that MSHA uses are that management knew or should have known of a volatile condition. And then there's a discussion of mitigating circumstances. Now, that's also why no negligence is an option, because we cannot be negligent as a company, but we can still be found liable or responsible for the condition observed. But as we get into those higher negligence rankings, whether it's high negligence or reckless disregard, those are going to be trigger points for some of the more severe issuances that MSHA has. Another part of this that we're going to talk about a bit more when we get into 104Bs is the assignment of abatement deadlines or termination deadlines, because those are important, that we have to make sure we're looking at those when a citation gets issued and that we're doing something to either complete the abatement by that time frame determined or taking some step in order to get an extension from MSHA. So as we talked about in the last slide, this is just a bit more of a breakdown. So we know what the gravity is, we've mentioned that, we know what the severity is. Significant and substantial, in order to have an S&S citation in terms of what boxes need to be checked, you have to have a severity designation of at least lost work days or restricted duty or higher, so lost work days, restricted duty, permanently disabling, or a fatal determination from the inspector. And the likelihood of occurrence, or the gravity, has to be at least reasonably likely, or highly likely, or occurred. So that's to say, if you have a citation that is determined to be unlikely that it was going to occur, regardless of what the injury was, you're not going to have an S&S citation, or you should not. The likelihood of injury is a main factor there. It's obviously very easy for MSHA to determine that an injury could result in lost work days or restricted duty, because almost any injury has that capability, or any anticipated injury. It's really that likelihood. Is it reasonably likely or is it unlikely to occur? That is a big linchpin of the S&S determinations. And what we have on the screen right now is MSHA's test, a paraphrasing of MSHA's test for S&S violations. And this is, these factors are largely called the Matthews test, or the Matthews factors, and that's because Matthews Construction was a company that litigated the determination of a significant substantial violation, and the end result of that case was this test in order to evaluate whether or not a citation was S&S. The first one is the underlying violation is of a mandatory standard. That just means that MSHA observed something that they believe violated one of the regulations in the Act. It's a pretty low bar. The second is the existence of a discrete safety hazard which was contributed to by the violation. So, whatever was observed was a violation of an Act or standard, and it created some kind of safety and health risk. Again, this is a relatively low bar. If we are arguing about S&S citations with MSHA, if we're contesting them, whether that is at the time of issuance, or that's an informal, or it's informal, or it's before a judge or the commission, we are likely going to be focusing on factor number 3. Is there a reasonable likelihood that the hazard contributed to will result in an injury? So this is all about moving the needle on the gravity section. So is it reasonably likely, is it unlikely, is it highly likely? That is what factor 3 is looking at, and that is where we usually have to make our arguments and our stand when we are challenging one of these citations. The last one is a reasonable likelihood that the injury in question will be of a reasonably serious nature. And that goes back to that other factor of the severity of the injury. Is it going to be lost work days or restricted duty as a probable or an anticipated injury, or more severe? So again, that one is also, we spend a lot of time arguing that with MSHA, but it is not as good of a place to make the argument as if we're looking at the third factor in this test, because we have to essentially argue that no injury would result. And that is, something that MSHA typically does not subscribe to. So just a bit of background on the S&Ss. As we mentioned before, the reason these are important are because they are reportable for publicly traded companies. They are largely based on the inspector's opinion of the matter regarding likelihood or the severity of the injury. So there's a lot of subjective influence in the issuance of an SNS. And as we mentioned before, they're flagged, whether that is in the pre-qualification process, if we're a contractor who's received an SNS, or if we're an operation, you know, inspectors look at that. We haven't heard about it as much with this administration, but the SNS calculator was something rolled out in the prior MSHA administration with Joe Main as the Assistant Secretary of MSHA, and what that did was MSHA tracked what your SNS rate was at your facility compared to other like facilities around the country. And if your SNS rate, number of SNSs issued per inspection hour or per inspection day, was higher than the national average for your facility, back then you were going to be subject to more inspections. So they still are an important factor. The SNS calculator has not got as much attention as it used to. I believe it is still functioning on the MSHA database, unlike the Rules to Live By calculator, which I think has since been removed, as that is not an emphasis of the administration currently. But nonetheless, SNS do matter, and that's why we wanted to take a couple minutes and talk about them and how we get to that point. So with that, we'll start on our first, we'll call it alphabet soup of the MSHA issuances, and this is a 103A. Now, 103A serves a couple purposes, and the first of which is denial of entry into an operation. This usually doesn't happen, but it does occur every now and then. I think just a few years ago, there was some significant action regarding denial of entry at an operation in North Dakota, if I recall that correctly, and it was essentially the exact situation play out. An inspector came to the mine site. The individuals were working behind a locked gate and would not let them in, and they attempted to do so. There was a an impeding the investigation claim brought up, as well as a denial of entry. So at that point, MSHA leaves and they return with law enforcement, typically federal law enforcement. And you are likely going to have multiple stages of litigation following that. If you ever are in the position that you are denying entry to MSHA, I hope that we don't get to that point. Because if you are a mine site, MSHA has authority to be there. Now, the question always will come out, if you are denying entry, it is likely because you have a question of jurisdiction. And if that is the case, you need to be prepared to move quickly and hopefully have already thought about whether or not you are under MSHA's jurisdiction and have an argument in place or have at least some anticipated steps in place to handle if MSHA comes on site. Now, I don't often encourage people to just lock the gate and tell MSHA they're not allowed to come on site, because that will get the expected result of returning with law enforcement. If you believe you have a situation where MSHA does not have jurisdiction over your facility, that should be made known to the inspector immediately. There should also be arranged telephone calls with district or field office management to have that discussion. And if you get to the point where MSHA still is saying, well, we believe we have jurisdiction, we're coming in to inspect, everything should be couched with the argument that they do not have jurisdiction for what they're doing at that point in time. And a 103A can be contested as well, as I said, but you want to make sure that you're contesting this by filing a notice of contest with the Federal Mine Safety and Health Review Commission, which is that third party that hears litigation between us and MSHA, us being operators or contractors. So we'll talk about a bit more later what goes into filing a notice of contest, but for now, just denial of entry are probably very much not the most common ways we come in contact with 103A. That is going to be impeding the investigation. And this is often brought up much more than it's used by MSHA inspectors. And there has been times where, I've heard of MSHA inspectors threatening impeding the investigation because the member of management who was going to escort them or the person exercising the company's walk-around rights wasn't available quick enough, or because they wanted, documents that were outside the required records and the company wasn't prepared to provide them. What impeding the investigation means is that they feel that the mine operator is either delaying or interfering with the investigation process. Another way that impeding the investigation comes up is if there isn't an accident investigation or there is an incident investigation or something of the like, and there is requests for interviews with miners. And if MSHA feels in any way that the management is somehow trying to interfere with their ability to conduct the interviews or interfering with or trying to push mine employees one direction or another about voluntarily participating in the interviews, we often have threats of impeding the investigation levied by the inspectors. So, we talked a lot about the impeding the investigation in our last webinar about MSHA record requests outside the scope of required records, just because that's another time we see it. As we mentioned there, this is a risk-benefit analysis. So obviously we know what our miners' rights are. We know what we can and cannot allow them to do or prevent them from doing. Any interview with MSHA is entirely voluntary. Any miner can choose to participate of their own free will or not participate and decline to interview with MSHA. They can have anyone of their choosing present during the interview. But one of the main elements there, if we're talking about interviews particularly, is management cannot influence those decisions. And that is, again, one of those risk-benefit analyses that we have to see how we are going to deliver that message, when are we going to deliver that message. We want it to be as black and white as possible. Now, we want to avoid getting into these impeding the investigations just because they can be issued under Section 103A, and they can carry a penalty. They can be the basis for 110 actions against agents. They can also, if we're talking about an interference situation, be the basis of a 105C claim for discrimination or interference. So while, a lot of times there's a threat of impeding the investigation violation that never comes to fruition, if they do get issued, they have to be dealt with very quickly and very aggressively from a defense standpoint. And if you are ever in a situation where someone is threatening or you believe you're going to receive a 103A, contest should be filed immediately and immediate action be taken to begin preparing a defense. One other way that we see 103A come into play is with advance notice. And advance notice is informing an individual that MSHA is going to be arriving to conduct an investigation before the inspector gets on site. Now, because MSHA has warrantless search authority as part of their powers, they can show up whenever they want to conduct an inspection. As you all probably know from dealings with MSHA, they can sometimes be a bit vague about telling you when they'll arrive, even if they're in the middle of an inspection. So this was a recent case. It was decided by an ALJ back in August, but the question was whether or not a company provided advance notice under Section 103A when they requested a member of management to accompany an inspector. Now, that seems harmless in its initial description, and this is probably something that we all do, either a phone call or text or a radio request to some member of the company to come up and join MSHA for the inspection. Now, what I usually tell people is that is perfectly fine. That is your right to contact someone to accompany MSHA. But what we don't want to do is broadcast this over a mine-wide radio channel. And that is essentially what occurred in this case. There was a control room over a certain area of the mine, and when that person was asked by MSHA to get someone up there to accompany them, they made the request over the entire circuit. So everyone in that portion of the facility got the message, and they issued a 103A for advance notice. And the judge agreed with that. They found that it was advance notice because multiple persons were notified. It was broadcast over a large area that the inspector was then going to inspect. And that's the whole point. They want to avoid essentially the fire drill where everyone's fixing everything haphazardly or putting buckets over places that don't have guards. Whatever MSHA anticipates that we're going to do in that situation, that is what they're aiming to prevent. So just, when we're talking about advance notice, every operator has the right to participate in the walk-around. That is their right. They can bring someone up to accompany the inspector. You should always be doing that. You should also have multiple persons trained per shift to do that. Now, when we contact them, it has to be direct, though. So a phone call to that person is probably the best way so that it goes directly to a single person. We want to avoid doing anything that might broadcast it to multiple people and be construed as trying to make a site-wide announcement. So, it is something that is, rare, these 103As. I won't say they're very common, but, it was just decided on a case here in August, so they do get issued and they do still come up. Moving forward in the alphabet on 103 section, we have 103J and 103K. And the reason I put these together is because they are very similar, and oftentimes they are just the verbal and written form of the same order. So 103J is a verbal issuance, and 103K is typically that exact order reduced to writing. They are issued to protect and preserve accident scenes. Now, it shouldn't be issued solely to preserve an accident scene by MSHA. That's not the intent of Section 103J or K, but what it is meant to do is to secure a scene until MSHA can get there and determine that there's no hazard present, which might injure or cause harm to other members of the company. Now, even if the scene has been cleared and it's issued, we still have to vacate the area. We need to block it off. We need to prevent access once we get that 103J. MSHA actually has a standard under Part 50, 50.12, that is expressly for the preservation of evidence. And if you get a citation for preservation of evidence, it's going to be under that section. But you will get a 103 that outlines the area that has to be withdrawn and is subject to MSHA's investigation until they determine it can be released. And the determination is that there are no hazards present, or that the hazards present are identified and protected against and not going to add to any concerns. These most commonly come up when there's an incident or an accident investigation going on. So if we call MSHA because of the 15-minute rule, because there's a death of an individual at a mine, an injury that has a reasonable potential to cause death, an entrapment, or any other accident, and I will just bring up this for edification. This is what MSHA defines as an accident, right? It's those 12 individual instances, which really are very broad, especially when you consider one as an injury to an individual, which has a reasonable potential to cause death. But I just want to make everyone, that is what we're talking about when we say accident. If we call MSHA within that 15 minutes, we're going to get their hotline, which is that 1-800 number. We will then get a phone call back from someone at the district level, whether a district manager or assistant district manager. When that person calls us, we will probably receive a 103J order by phone. So the verbal J order, that's a withdrawal for the area where the incident occurred. It is typically limited to where that incident actually occurred, but it is important to know that, it can be more broad. And if an inspector gets on site or through discussion with the district personnel, it's determined that the hazardous condition that led to the accident exists elsewhere at the mine, the J and K orders can include every area that is similar. So that's something that we definitely need to be aware of, because the scope of 103J orders and 103K orders are usually the most difficult part of dealing with them. You know, I will say if there's an instance where you can try and tailor back in the scope of it, maybe geographically how wide it is, then it will allow continued operations but for that area. That's something that needs to be discussed with MSHA at the outset. MSHA does allow for modification of 103K orders once they're reduced to writing, and that would typically happen as soon as the first inspector gets on site. And that can be either resume operations normally or on a limited basis. But in order to get any modification to a 103J order or 103K order, there's a lot of steps that go into it. You have to outline exactly what you're looking to do, unless you're looking for a termination of the order. We have to outline a step for safely performing whatever that function might be. Typically, that has to be a procedure put into writing, which is then reviewed by the issuing inspector and the on-site investigation team, and then sent to the district, and then either approved or disapproved by both parties. And then we're granted the opportunity to perform that function typically under the close observation of MSHA's personnel. So 103J orders and K orders is typically issued during an accident investigation or an incident investigation. If that is the case, they can be quite burdensome, and quite a bit of effort has to go into terminating them or modifying them, and that can be to allow for the completion of the investigation or for bringing something back up to operation. But really, MSHA kind of holds our hands in this situation. If we are looking to contest the scope of a 103J or K, and typically that's because it shut down all operations maybe when it could be more limited and some operations could continue. An example might be if there was a crash off a main haul road, but instead of limiting it to that area off of the haul road, MSHA shut down the maiden road to the plant on that haul road between the pit and the facility, and we cannot do any driving on it. But that is not subject to the incident because the equipment is off the road and it's in a different location now. That's one where you probably want to look to push back on MSHA and maybe even file contests to have that limited in scope. Another one would be if there is a high wall that is, your entire pit area and it's many hundreds feet long, and they just stop all extraction in the area as opposed to maybe a smaller area where there was a fall of material hazard or occurrence. If those instances are happening, we want to definitely contest, we want to push back. Those sound both to me like candidates for requests for expedited proceedings. So that has to be done through a notice of contest within 30 days of issuance, and there has to be an additional written request for an expedited proceeding, which means that you can get to a judge relatively quickly if needed. So when we, have a lot to consider there. Typically 103J orders and 103K orders do not have penalties assessed, but there might be other citations that refer directly to them. As with anything that does not have a penalty assessed, if we want to contest it, we have to file a notice of contest within 30 days because we're not going to get the opportunity to contest once penalties come out. The next item on the list is 104B orders, and 104B orders are a failure to abate, and that is a failure to abate a hazard identified in a previous citation or order. This is an immediate withdrawal for the area of the mine or equipment subject to the underlying citation or order. They typically do not have a penalty associated with them, but can have a very, very severe penalty of almost $8,000 a day that it remains uncorrected. Again, since this might not and probably won't have a penalty, if you get a 104B, you need to file a notice of contest to the Commission within 30 days of issuance. And so what is the status, or what is the qualifications for issuing it? The language at the bottom is from MSHA's Field Operations or Citation Handwriting, Citation Order Writing Handbook, and it says an inspector must determine there is no reasonable basis for extending the abatement date. So, you know, have we done anything to pursue abatement of the hazard? That would be my question to you. Has anything been done? Have we ordered parts? Have we barricaded the area? Have we removed the equipment from service? If any of those has happened, or probably a combination of those have happened, and we haven't abated it fully, but we have done something to prevent the hazard or prevent exposure to the hazard, we should not be getting a failure to abate. Failure to abates are most commonly issued when it's pretty egregious that nothing has been done to correct the hazard that the inspector issued. In terms of requesting an extension on abatement, that's something that we can do at any point in time. We can do that at the time of issuance when we get a copy of the citation and we see what MSHA said is the abatement date. If the abatement is unreasonable, meaning, you know, it's going to cost an exceptionally high amount of, or a large amount of money, or it's going to be widespread, again, those are times where we need to prevent a 104 from being issued by engaging in some proactive discussion with the inspector and, you know, if needed, the field office in the district in order to really drill down into what is a reasonable abatement here. I've done some heavy redacting on a citation that I had, but I wanted to highlight a couple issues. Now, this wasn't a 104B order. This was a 104A citation. It was a non-S&S citation issued to a client of mine back in April. And the only thing I really want to pay attention to here is that the abatement date and the issuance dates. Now, we should know that the issuance date is the very top line of a citation. It was issued on April 3rd, 2019, and it was issued, according to the inspector, at 8 a.m. or 8:18 in the morning. Down at the bottom, though, in the next highlighted or circled area, we see line 16, termination due date, or due. And it's saying that the termination is due April 3rd, 2019, so the same day, at 12 p.m., so at noon. So the inspector gave the company 3 hours and 42 minutes to abate this violation. Now, that might have been entirely possible, and in this case, it looks like it was, because on line 18, we see that the citation was terminated at 9:30 in the morning, so an hour and 15 minutes after it was issued. But the reason I bring this up is line 16, that date that termination is due, that is made up by the, or decided, I should say, by the inspector. And unless we pay attention to it when we get a copy of the citation, that is what we are held to. Now, if, you know, say someone got this citation and they looked down and said, hey, there's no way we can possibly get this fixed by noon. We got to order parts in, they're 2 days away, you know, we're going to need some additional time here. The inspector would probably give them an extension until that time could be met, something reasonable. But if you don't pay attention to that date and the inspector comes back the next day and sees you've done nothing to repair that part or abate that condition because you're waiting on parts to come in that are 2 days away, that is when a 104B can be issued. And I think that, you know, no reasonable basis, you know, there's no reasonable basis for extending. That's when they have to issue a 104B, but that's very subjective. Okay, again, we are dealing with the inspector. Hopefully we have a good relationship with our inspector, we're keeping them abreast of what's happening, and we've told them we're going to need some additional time, and that is usually readily given. But to really avoid 104Bs, we need to pay a lot of attention to that termination due date. Because if for some reason you're in an inspection that is a bit contentious with the inspector, I've seen them show up and they say, well, you know, abatement was due this morning at 8 a.m., it's 9 a.m., I'm here, and the condition isn't repaired. So I'm going to give you a 104B order. And then that entire piece of equipment is signed out until it's repaired and MSHA has approved that abatement. So the best thing to do with a 104B is just to avoid them. Another way that MSHA has been using 104B orders recently is with their scofflaw program. Now, I'm not sure how many of you are aware of the scofflaw program. I've mentioned it before on the webinars, but it is MSHA's attempt to collect penalties from those companies with delinquent fines. And the way the agency has figured out to do this, and quite honestly, it is a good strategy, is if you don't pay your fines or they come across your mine's name, they will issue you, a letter that says you have to pay them. If you don't pay them, they will come out and they will, again, give you notice that you need to pay the fines. If you don't, and then at that point, they will issue you a 104A citation for failing to comply with a provision of the Act about paying fines and about being in compliance and adhering to MSHA's regulations. Okay, so you have a 104A citation. What happens next? They come back in a week. And if you have not paid off your debt in full or made a payment plan with the agency, they issue a 104B for the entire operation, which means they shut you down. That is really a strategy that was developed a few years ago, or not probably many years ago, but really came again into litigation a couple years ago when there was an incident and MSHA was requesting contact information for every miner at the mine, and the company was only offering to give them, the contact information for the persons in a certain area on the shift that the incident occurred. So, the company and MSHA are arguing for an extended period of time about this scope of the information request. And what MSHA did is eventually the district manager issued a citation for failing to provide the needed information. It was a 103A for impeding the investigation. And then they still wouldn't provide it, as was expected. He issued a 104B for the entire mine and shut down this massive operation because they were fighting over document production. So that just goes to kind of show you the scope and the power of a 104B order. Just if my personal opinion means anything to you, I think it is probably one of MSHA's strongest and most underutilized orders, and I think that's a good thing that it's underutilized, but we should all be paying particular attention to its requirements and how to prevent it so that we never have to get in that situation, because 104B orders are no fun to have to deal with. It gives the agency a lot of power in controlling how you're going to abate a situation. So the next one is, again, probably the second most common issuance that we've talked about so far, behind 104As, but 104Ds. And a 104D order or a 104D citation. Now these are all oftentimes also referred to as unwarrantable failures. And MSHA defines that as a violation is caused by an unwarrantable failure if it is determined that the mine operator or contractor has engaged in aggravated conduct constituting more than ordinary negligence. Specifically, if we're looking at what it takes to receive a 104D1 citation, we're looking at it has to be a violation of mandatory safety and health standard, it has to be an S&S violation, and there has to be an unwarrantable failure that the contractor or the mine operator did not comply with that. Now, when we're saying there has to be an unwarrantable failure, that's what we're looking at in terms of negligence. So, has aggravated conduct constituting more than ordinary negligence occurred? And so to determine this, determine the negligence of the company, and if they had aggravated conduct, making a citation eligible to be an unwarrantable failure, if we're following that train of thought. MSHA looks at how long the condition existed, how widespread it was management in the area, or were they on notice that greater care was required? And greater notice that greater care was required can be, you know, it was an ongoing issue at the plant, or you received a lot of citations on a particular hazard, so you should have been paying more attention to them, or there were employee complaints about a specific item or a specific practice. Those go into that greater care was required. The next one is, had management taken steps to correct or abate the condition? So had we already taken some action and it just maybe wasn't working out the way we anticipated? Or did management know, or should they have known, of the condition? So these aren't a list that we have to check off every one. It can be that multiple apply, or one applies, or that one applies a great deal and the other one's just a little bit. It's not a and list. So it isn't how long did the condition exist and was it widespread and was management in the area. It's an or. So it can be some combination of these factors determining that aggravated conduct was present, or just one of them that was quite egregious. Typically, if it's a one-factor situation, you know, the thing that I often come to is, because I've seen these issued, is a 104D for failing to wear fall protection when management's in the area. If that occurs, regardless of if it's never happened or it existed for only a short period of time, or, you know, management didn't see the person but they could have, you know, there was training in place, there was fall protection around, but someone just didn't use it and management was working in the area too, that is going to be a 104D, most likely. They're frustrating, but nonetheless, that's a situation where we're probably going to get 104D issued. So that's how we determine aggravated conduct. Now, it's always going to be probably high negligence or reckless disregard on that initial citation. And then we'll have a decision if we're going to have a 104D order or a 104D2 order. So a D1 order must be issued within 90 days of that D1 citation for another unwarrantable failure. And then a 104D2 order is issued for any unwarrantable failure observed during any subsequent inspection with, you know, during any subsequent inspection until the mine is inspected entirely, a regular safety and health inspection without an unwarrantable failure found. So when we talk about 104D1 citation, 104D1 order, and 104D2 order, that is what you've probably heard of before as the D chain. So we have to receive that first 104D1 citation, and that begins us being eligible for the D chain. In order to move forward, we have to be issued another unwarrantable failure, a 104D1 order, within the next 90 days of that 104D1 citation being issued. If there is no second unwarrantable failure issued in that first 90 days, then we start back at the beginning. If we're going to get an unwarrantable failure, it's going to be a D1 citation. We're not on the D chain yet. If we get that second unwarrantable failure issued 89 days after a D1 citation, we are now moving forward in that D chain. After that, any unwarrantable failure issued is going to be a 104D2 order. And it doesn't even have to be S&S at that point. They're going to be looking at the aggravated conduct. So, was greater care required? Should we have known about it? Did management know about it? The other difference here is a 104D1 citation, like that redacted citation we looked at earlier, that was 104A, it will have an abatement time, all right? It's not a withdrawal order. It will have an abatement time. You have to fix it by that time. Now, I shouldn't say it's not a withdrawal order in that, like, you have to abate it, and you have to do so quickly and expeditiously, but it is not a withdrawal order in that 104D1 orders and 104D2 orders are withdrawal orders for that area, that practice, that piece of equipment, until MSHA approves abatement. So it's a 104D1 citation. We are just given an abatement deadline. We can repair it, we can perform that abatement, and at that point we can enter it back into work. If we get a 104D order, so a D1 order or a D2 order, abatement has to be approved and verified by MSHA, which takes some time. So it means someone has to come out to the facility. So that is an important distinction in them. In order to get off the D chain, if we're in the part where we're actually getting D2 orders, I should say, I'm sorry about that, we have to have an entire regular safety and health inspection without any 104Ds observed. Now, it's not nearly the monumental task of getting off of a pattern of violations by having an inspection without any S&S citations issued, but if we are in a situation where we're receiving a lot of 104Ds, we're on that D chain, you know, the bar just gets consistently lower because aggravated conduct means we should be at heightened levels of sensitivity and inspection and awareness around the facility, and MSHA very much looks at it with that lens. About the D1 citations and orders, they do carry heavier fines. Their minimum penalty on a D1 citation or a D1 order is $2,400. The maximum under normal assessments is $7,200. If it gets a flagrant designation, then that's MSHA's highest penalty. It can go up to that $266,000. Those are very rare, only a handful issued a year. In terms of 104D2 orders, the minimum is now $4,840. Now, those are incrementally increasing every year since the Inflation Adjustment Act was put out. For many years, it was just $2,000 and $4,000 for a 104D1 or a 104D2, and then it went up, and then it came back down when the Inflation Adjustment Act came out because the subsequent increase was outside of the rulemaking, and so it had to be vacated. But now MSHA every year in January, so we're coming up on another bunch, gets an increase in their penalties. So just remember, if we're getting 104D orders, this D1 citations, we can do abatement. D1 orders, D2 orders, those are withdrawals. MSHA has to approve our abatement and has to verify it. Now, if we're getting these, you will get penalties, so it's not essential that you do a notice of contest, but you should file a notice of contest within 30 days. D citations are also very much and very usually the basis of agent investigations under Section 110 of the Mine Act. They're important to get a hold on quickly, hopefully during the inspection. Just some brief, footnotes on what I would recommend. If an unwarrantable failure is being issued, the named supervisor, named in the body or in this service, should try and not participate any further with MSHA during that inspection, if at all possible. And that's, again, why we want to have multiple people trained. Just because everything that's going to be said at that point forward is going to be used or could be used during a special investigation into that individual's personal liability. So we want to keep that very much in mind as we go through things. The next type of withdrawal order is a bit more straightforward, but it's a training order, so the 104G1 orders. And this is a withdrawal order for untrained minors. And if this is issued, and it can be issued for, not having new minor training or not complete new minor training, or not having their task training or refresher, or even it can be issued for site specific. If people are failed to have that, they are removed from the mine site until training can be completed. Now, if it's task training, they will be removed from performing a specific task. That doesn't mean they have to leave the site as long as their new miner or their newly hired experienced miner and annual refresher up to date. But these individuals have to be removed until that training can be provided. Now, one area where I see this sometimes get issued inadvertently is 104G orders with task training, where task training has been provided, but perhaps during questioning a minor blanks on what the response to a question might be from an inspector. It seems like most of the time these questions where people blank are having to do with auxiliary systems, whether auxiliary powering or auxiliary lowering on a man lift or secondary steering on a haul truck. You know, if we have provided task training, we have record of that training, and we know what materials were used to provide that training, and part of that materials was reviewing the operations manual on that piece of equipment, typically you can get those 104G orders vacated. Another time where 104G orders can be issued and you can get them thrown out pretty quickly, or at least modified to a 104A, is if you're in a situation where MSHA requests records, training records, but you don't provide them in a timely fashion. So for training records, if MSHA requests them, we have to provide them that same shift. If we don't, MSHA assumes the individuals are untrained and can issue and likely will issue a 104G order removing them from the site. Once we provide those documents, there is another standard that is for failing to provide documents in a timely fashion. We should have that citation modified. Especially if we're a contractor, we don't want any 104Gs on our history. Those are especially looked down upon by pre-qualification, whether it's software or someone individually reviewing your record. We'll speak quickly about the flagrants because I mentioned them earlier, and they are really relatively rare, but this is for a reckless or repeated failure to make reasonable efforts to eliminate a known violation of mandatory health or safety standards that substantially or approximately cause or reasonably could have been expected to cause death or serious bodily injury. What does this mean? These are MSHA's most severe, strongest citations. If we are seeing flagrants, there was a lot of really bad things happening in that we were probably ignoring hazards or having multiple failures, and that can be from repeatedly getting unwarrantable failures or SNS citations about a specific standard. But to get a flagrant, if it's a reckless failure, it has to be evaluated as an SNS citation. The injury has to be at least permanently disabling. It has to be an unwarrantable failure, and the negligence has to be reckless disregard. So it is a very high bar. This is a culmination, of many, many things. You have an SNS, you have a permanently disabling or fatal anticipated injury, you have an unwarrantable failure, so there's already aggravated conduct alleged, and then the negligence is the highest it can possibly be. There's another type of flagrant citation, that's for repeated failure. And so in order to qualify for repeated flagrant, you have to have a citation that is SNS again permanently disabling or higher, again marked as an unwarrantable failure. However, you have to have 2 prior unwarrantable failure SNS violations of the same standard in the past 15 months. That can be issued during the same day or during the same inspection, but it has to be within the last 15 months to qualify for a repeated failure flagrant. And that has to be the exact same standard and subsection. So if we're talking about, guarding, it has to be multiple unwarrantable failures under, for example, on a surface operation, 56.14.107A. It has to be that defined. So these are rare. We don't see them very much. They are typically in very egregious situations, but nonetheless, this is what a flagrant is referred to if you've ever heard that time. It comes under Section 110B of the Act. The next one, as we're moving through, and we have a couple more to cover, so I will go as quick as possible here because we're butting up against the end of the webinar time, and I try not to keep you all over, is a 107A imminent danger order. This is a fairly common order. It got to be used a lot more in the last 5 to 7 years. I think that use has, again, receded a bit in the current administration, but at the end of the Joe Maine and the Obama administration of MSHA, it was being used quite regularly. There is not a fine associated with an imminent danger, but there will be a corresponding 104A or 104D issuance that will have a penalty. Typically, those will be issued as high negligence. Oftentimes, they are unwarrantable failures. But an imminent danger can be issued when an inspector observes a condition which they believe could reasonably be expected to cause death or serious physical harm before it can be abated. It is a withdrawal in that service area, that practice, that equipment, whatever is subject to that order is immediately removed from service until abatement can be verified by MSHA. So they are a relatively strong order in that if MSHA sees someone doing something unsafe, they can immediately say that I'm issuing a verbal 107A or verbal imminent danger order, and that person is removed from service and removed from doing that task. They do not carry a penalty, as I mentioned earlier, so we need to make sure if we get a 107A that we plan to contest, we file that notice of contest within 30 days, because we will not have the opportunity to contest when the penalty comes out for the associated 104A or 104D. Again, if we're a contractor, we really want to look at these. If we're a mine operator, we want to look at these. 107As are, again, reportable. I believe they are a triggering event for immediately reporting if we are a publicly traded company. So we want to avoid those and avoid having them maintained on our record. I always bring up this one citation because a 110G is an interesting item, but it is when a miner was found willfully violating standards related to smoking. You know, people always ask, when can miners be fined? Can miners ever be fined? This is one of the rare occasions where a miner can be fined, and they can get, it's not much, but a $330 penalty. Now, if you are an agent of management or the individual cited for willfully violating the standards relating to smoking in an underground coal mine or in a restricted area, an underground metal non-metal mine or surface area, they will bring a 110 action against you. There will be a 110 action into civil or criminal liability if you're an agent of management. But if you're a rank and file miner, you can get a citation. The kicker is, in this instance, if there is a 110G issued about this, the mine operator and the contractor, or the contractor who employs the individual, shall also be issued a citation and possible imminent danger order. So, you know, that is a bit of a, you know, they're going to punish they put in this mechanism for punishing egregious activity by the miner, but in addition, the company's going to get hit as well. And if you're an agent of management, you're going to be looked at for additional liability. Now, there's been some people I've talked to around the country who think something similar should be put into effect for seatbelts. I'm not sure that that's going to happen. This is specifically in the Mine Act, so to add anything to this section would have to be Congress making the addition. But it is that's an interesting concept to make, you know, some kind of penalty for individuals who refuse to wear their seatbelts. The thing I would say about that is, in this 110G notice for willfully violating smoking standards, if the individual gets a citation, the company also gets one. And that would, I imagine, be the same treatment if we had it for seatbelts. So, you know, we're rounding it out. I just wanted to talk a little bit more about contests, because that is one of the things that has to be considered if we're getting those citations outside of 104A or 104D. We need to know what we should be doing with the contest. So, you know, the first time we can formally contest something, and this is before assessment, so before that penalty assessment even comes out, is filing that notice of contest with the Federal Mine Safety and Health Review Commission. The second opportunity is when we get that penalty sent out from MSHA, we get that in the mail. That's our second time to initiate assessment or formal contest after the assessment's issued. Notices of contest, though, have to be filed within 30 days of receipt of the citation order. We usually don't get proposed assessments from MSHA for at least a month, maybe several months. So if we say, oh, we're going to wait and see what our penalty comes in at before we contest that 104B or that 107A on the associated citation, it's likely too late. And to file a motion to reopen with the Commission is a multi-year process of frustration where we file this document and then we just have to sit around and wait for a ruling. So please, if you're getting a 104B or a 107A, and I recommend it for 104Ds, or anything else that you have questions about. We talked about a lot of different citations and orders that can be issued. Think about filing that notice of contest. Okay, call me up. I'm happy to talk to you about a situation, give you my thoughts on whether or not you should file it. Happy to help you file one on your behalf, or help you do it. You're going to send it to the Commission itself. You essentially just have to submit a form stating you deny the alleged violation occurred. You want to state the date it was issued and include a copy of it. And that is the bare minimum. But you really need to consider it within 30 days. If we're going to do formal contest after assessment, so that's after we get that petition in the mail, or that proposed assessment, we have 30 days from the date that proposed assessment is received to get our contest into MSHA. Now, it has to be received in writing by MSHA, so do not wait until the last minute on those 30 days. You do not have an electronic filing option, which is somewhat ridiculous at this point in time, but you still have to send it in by mail. You can try doing it by fax, but it is not always received, and mail is how you must also submit it. So make sure you're paying attention to when your notice of proposed assessments come in the mail, and that you are making note about when your deadlines to file are. And that is, important for any citation. But again, that is for a 104A, 104D most commonly, and you're going to get a penalty on them. If there's no penalty assessed for the citation, so a 104B or a 103A, which might not have a penalty, or a 107A, you're not going to get a chance because you get an assessment in the mail to contest it. That has to be done by filing a notice of contest. With that, that's us rounding up. So, as always, please take a look at the blog. We'll be posting something here in the next day or so. Just a reminder that coming on January 1, we are all going to be responsible for adhering to the new provisions of the workplace exam rule. So remember, we have had some modifications to the metal non-metal workplace exam rule. We used to have the option of performing the exam before or as minors entered a working area. That is no longer the case. All workplace exams have to be done before a minor enters a working area. Additionally, with regard to record keeping, we used to be able to omit from our records any adverse condition that was corrected before minors were exposed to it. So, this is a very basic example, but it's the example I'll continue to use. If we're walking on a catwalk and there is a hose piled up in the middle of it, that's a tripping hazard, and we saw that on our workplace exam and picked the hose up and hung it in its appropriate spot next to the catwalk, therefore eliminating the tripping hazard. Under the final rule we've been adhering to, we did not have to write that as an adverse condition observed or make note of the corrective date, the date of corrective action on our exams. Now, starting January 1st, we would have to include on our workplace exam hose in the catwalk, removed on this day. So just beware that is happening January 1st is going to be when enforcement begins on it. The rule went into effect a couple months ago, but they did a 90-day stay on enforcement. So January 1 is when it becomes really enforceable with the agency and its inspectors. So beware of that coming. Also, want to thank you all for joining me today, and many of you for joining along the year for the 2019 MSHA webinar series. Also look out for the blog because we're going to be putting up the schedule for the 2020 MSHA webinar series. As always, if you have any ideas on something you think would be a very good topic that you'd be interested in hearing about, and maybe others too, always, shoot me an email or fill out the post-meeting survey and let me know what those might be, because we're in the process of finalizing the 2020 series. So thank you for joining. If there's any questions, feel free to submit them through the chat function, or you're always welcome to reach out to me directly. All of my contact information is up on the screen. All right, it doesn't look like we have any questions coming in, so I just want to again thank everyone for joining us today, and have a very happy holiday, and we'll talk to you all again on the webinar series in 2020. Thank you.